The New Zealand Dispute Resolution Centre is launching a new alternative dispute resolution process to try and address a big backlog in disputes getting to court. I'm joined by NZDRC Director John Green. John, thanks for coming by. Why don't you tell us a little bit about this new contractual adjudication process to start off with?
Sure, no, thank you. It's a new dispute resolution process and service that's been designed and delivered by NZDRC domestically and NZIAC, New Zealand International Arbitration Centre, on the international scene. It's a fair, prompt, cost-effective and efficient and proportionate way of resolving disputes. It's a creature of contract. It's based largely on the statutory adjudication process under the Construction Contracts Act, and ultimately it will deliver a determination that is binding and enforceable, but not necessarily final, on the disputed matters within 35 working days. So look, it's quick, it's prompt, and it is very, very efficient and effective.
So who are you targeting with this process? What sort of businesses or people might look to use this? What sort of disputes might be coming up or coming to you guys?
Basically anyone and everyone that has a dispute of some kind that can be resolved by an alternative means of dispute resolution. There will be certain matters, of course, as a matter of public policy or as a result of certain legislation that are not capable of determination other than by the courts. But by and large, any matter that is capable of being civil matter, commercial matter that is capable of being determined by arbitration, for example, is eminently capable of being dealt with by adjudication.
So what's the problem you're trying to solve here, I suppose? I mean, you do anecdotally hear about backlogs in the courts, but just how bad is it out there?
You do. Access to justice. I mean, we're really responding to a demand by the business community for access to an accessible form of justice. And contractual adjudication provides a practical response to that problem. I mean, at the moment, I think the delay in the district court is something like 883 days from filing to disposition and 650 days in the High Court. I'm not being critical of the courts. They're under huge pressure, and COVID certainly hasn't helped. But that doesn't answer the immediate demands of the business community to resolve conflict, to resolve disputes, so that they can get on with their core business activities, which I can assure you don't involve dispute resolution on a daily basis, they would hope.
So, say I'm a business with a dispute, I come to you guys looking to use the arbitration process, presumably I still need a lawyer and things like that?
Not necessarily. And as I say, it is a creature of contract, so the parties will have to agree.
Right.
So where will that and how will that agreement take place? Typically, we would hope in the underlying contract, we would hope that the transactional lawyers will start to include our model clause for adjudication in agreements and contracts for various transactions. That's the smart money, is having an agreement at that point in time when the parties are at least amenable to talking about things that are important to them. You know, once a dispute happens, of course, it's going to be more difficult, but they can agree at any point in time.
What's the sort of capacity that you guys have? I mean, say
Infinite.
Everyone all of a sudden floods to you guys. Is that turnaround time going to hold? Or?
Oh, look, infinite. We've got sufficient resources to be able to respond to the demand. Private dispute resolution in New Zealand is a mature and competent alternative to the court system, and we've got access to almost infinite.
How do you think the demand for sort of arbitration services more broadly is going as well? I mean, internationally, you've seen businesses sort of turn away from court just because of the time and the costs involved. I mean, is that a phenomenon happening here in New Zealand as well? Or?
It is. Funny you should mention that. We were just involved in a survey that we undertook in conjunction with a couple of our colleagues to try and gauge the use of arbitration in New Zealand. What I can tell you is that it is alive and well, and it's being used in many sectors that it perhaps wasn't used traditionally. I mean, it was really once again a creature of the construction industry. But what has happened in practice is that in the last 20 years, statutory adjudication has almost completely displaced arbitration as the dispute resolution process of choice for that sector.
Right.
Because it's quick, because it's prompt, and because it's cost effective.
And you'd expect that would be the same effect in the other sectors as well. Well, that's what you're hoping for, at least.
Yes, I mean that's what the business community is demanding and looking for, and that this is a way that we can respond.
John, thanks very much for your time.
My pleasure. Thank you.